Title is Pathways of Regularization in Italy, the Special Protection and the Amnesty for Undocumented Migrants. So let's start. This is the plan of the lesson. As said, we will have an introduction on what does it mean to be an undocumented migrant in Italy, and also some data and some, let's say, of the most relevant causes of irregularity. So why people end up being in a condition of irregularity on the territory, so being undocumented on the national territory in Italy. Then we will have an overview, as said, of the options, let's say, provided by the Italian legal order, the Italian legal system, for the regularization of undocumented migrants. Then we will quickly see the relationship between the non-refoulement principle and the implementation of this principle that you already saw in the lesson on the European asylum system and legislation, and how this principle is implemented into the Italian legislation. Then we will focus on the special protection, and we will close the lesson on the 2020 amnesty for undocumented migrants. So to introduce these, the topic of, let's say, legal pathways for regularization of undocumented migrants in Italy, is important, I think, to start from a principle that I already mentioned in my first lesson in this training course, which is the binding connection between the entry visa and the residence permit. So this is, of course, a key general rule of the Italian legal system, of the Italian legislation on immigration. And it means that third country nationals can only apply for a residence permit which is associated with the entry visa issued by the Italian embassy. So the entry visa that allow them to have access to the territory. This means, of course, broadly speaking, in general terms, that if a third country national enter the territory, the Italian territory, without an entry visa, without a visa, so without the authorization given by the Italian authorities, he or she cannot apply for a residence permit, for an ordinary residence permit, let's say, maybe it's better. This also means that if the third country nationals that get access to the territory with tourist visas cannot apply for any ordinary residence permits. And that this means, of course, also that there is a direct connection, okay, between the category of entry visa the person had and the category, the type of residence permit that she or he can apply for. Okay, so if you enter with a visa for working reason, okay, and of course there are many different types of visa for working reasons, seasonal work, employment reason, or specific working activities, then the person must apply for a residence permit for the same working reasons, okay, for the same category of the visa, the working visa he or she got from the Italian embassy in the country of origin or residence. This is very important because, of course, this is one of the reasons why many people end up being undocumented on the Italian territory. Because, for example, they enter with a tourist visa or without any authorization, and then they cannot apply for a residence permit for working reasons. This is also important as a general rule because we will see today what are the exceptions to this general rule. Okay, we will see what options what options third country nationals have in Italy, so according to the Italian legal order, to the Italian legislation on migration, have to get a residence permit, let's say, without having the right to an ordinary residence permit, such as a residence permit for work reasons, for study reasons, for family reunification, and so on and so forth. What does it mean to be undocumented in Italy? So, very briefly, of course, this could be, let's say, a topic of a whole class, of a whole lesson, or maybe more than one. But just to give you an idea, especially to the people who are not from Italy and who or that maybe study in or work in other countries and are not familiar with the Italian context and Italian legislation. Undocumented migrants in Italy cannot work regularly, so cannot be part of a labor contract, of a regular labor contract. Of course, many undocumented migrants actually work without having a regular labor contract, but that's another issue, and this will come back, let's say, in the next part of the lesson. We will go back to this point in the second part of the lesson. So they are excluded from the labor market, the regular labor market. They are also excluded from the welfare system. Okay, so they cannot have access to welfare services, to social housing, for example, or to subsidies, or any kind of welfare services. They only have access to compulsory education. So, for example, minors, even if they and their parents do not have a residence permit, minors can have access to education, to compulsory education, so basically to schooling. And actually, it is a duty of the parents to register their children to school, okay, to compulsory education, even if they are undocumented. And they also, and undocumented migrants also have access to healthcare, okay, but only to emergency rooms, okay, so only to the very first level of the healthcare system. They also cannot rent a house. Of course, I'm speaking about regular contracts, rent contracts. So they don't have so-called tenants' rights, okay? And many of these, let's say, of these prohibitions, okay, to which are addressed to undocumented migrants by the Italian law, are also enforced by criminal provisions, so by criminal offenses for those who help, or for those who, for example, hire, okay, and undocumented migrants. So employers who hire undocumented migrants can be charged with a specific criminal offense, and also people who rent houses or rooms to undocumented migrants also can be charged with a specific criminal offense. And basically these are the most important cases of criminal provisions that somehow enforce these exclusion from specific rights of undocumented migrants. And of course, undocumented migrants are always at risk of expulsion and removal, and as a consequence at risk of administrative detention, so at risk of being held into a detention center, an administrative detention center. And the detentions, the administrative detention of undocumented migrants in Italy can last up to 90 days, and for specific nationalities, there's also an additional period of 45 days. So, for example, Tunisian citizens can face up to 135 days in administrative detention. This is because this is because of their nationality, because the Italian law says that an extra period of administrative detention is allowed for third country nationals of countries with whom Italy has a readmission agreement. Okay, so it's not it is a matter of nationality, but there's not a list of course of nationalities that can be of people that can have these different treatment. Finally, undocumented migrants in Italy are always at risk of being charged with the crime of illegal entry and illegal stay. Okay, This is a criminal offense, of course, which has been introduced in Italy in 2009, and which is still there despite the criticism and the denounces of many NGOs and association and activist group, and also criticism raised by, for example, Italian associations of lawyers and judges and so let's say professionals from the judicial system. When you see this word, this is the abbreviation for the testo unico sull'immigrazione, which is basically the main Italian law, the most important Italian law on immigration. Not the only one, but the most important one. We could translate it with Italian consolidated law on immigration, which is basically the immigration code, the Italian immigration code, even though it's not a code, but that would be this is not an interesting point, let's say. According to the most recent estimates, in Italy, there are about 500,000 undocumented migrants. So more than 500,000 of people living in Italy without a residence permit, without a regular residence permit, and of course living in Italy in the condition that we just saw, okay, that we just mentioned. So without having access to the regular labor market, without being able to rent a house, or always living in fear of expulsion, detention, deportation, and things like that. So of course is a condition of marginalization, at least for the majority of people in this condition, without papers, without documents. There are multiple social, economic, and legal causes of irregular immigration, of these situations, so of these numbers, of these figures. One of the cause, of the legal cause, let's say, is these is the principle of the connection between the entry visa and the residence permit, as already said. Another cause is the fact that Italy in the last more or less 10 years basically closed the channels for regular immigration for working reason. So migrant workers couldn't come to Italy legally. Italy basically didn't provide room for in the for migrant workers to come. And so these, of course, led to more and more people coming through other ways and crossing in the borders in an irregular fashion. And of course, this is also, and some of them, of course, ended up in a condition of irregularity. Another cause, another reason is the economic situation of Italy, of course. Is very difficult for everybody, but especially for migrant people, to have a regular labor contract, regular employment, to, for example, renew the residence permit for working reasons. And so many people who used to have a residence working permit, residence permits for working reason, ended up in being irregular, undocumented, because of the of the difficulties to get a regular employment with, and to meet all the requirements for renewing the residence permit for working reason. These are, of course, only some of the causes. There are, of course, more, but this was just to give you a quick introduction to the topic. Here we have these, in this slide, we see an overview, a list of the options provided by the Italian legislation to regularize the position of undocumented migrants who are on the Italian territory. I didn't list the asylum request, okay, and the statelessness recognition. I didn't mention the asylum request because you already had a class on asylum, and we will have a round table on asylum in a couple of weeks. And of course, asylum is a specific, let's say, field, is a specific area, and I didn't want to mix the topics. And I didn't list the statelessness procedure because it's quite rare, and of course it only applies to stateless people, which are most of the time not even migrants, in the sense that they already that they have been living in Italy, they and their families, for a lot of time, for generations. So I only listed the let's say the residence permits, the types of residence permit that can be under specific conditions, of course, meeting the requirements, of course, can be used, okay, to regularize the position on the territory. So basically to get a residence permit, and without without having to respect the principle of the connection between the entry visa and the residence permit. Okay, so this is a list. I hope I didn't forget anything, but it could happen. But this is a list of non-ordinary residence permits, okay, provided, foreseen by the Italian legislation. Of course, if there are things that are not clear, if I have to clarify something, you can write it in the Q&A chat, or if there are questions, I will of course answer. Okay, the first let's say set of residence permits that you see in this slide in this slide are, let's say, concern cases of so-called non-returnable migrants, so people who cannot be deported, who cannot be removed for different reasons. And in this list, we see the special protection that we will analyze in a bit, in a while. Minors, because in Italy, minors cannot be removed, cannot be pushed back, except for the case that they that also their parents, okay, are removed, are deported back to their countries, to their country of origin. So only in that case minors can be deported. But for example, unaccompanied minors can never be deported in Italy, and they cannot even be detained for immigration control purposes. Okay, so you shouldn't find, you shouldn't ever find a minor inside a detention center in Italy. This, of course, happened many times. This was, of course, I mean, there were many cases of people, of minors detained because, for example, they were considered, I don't know, adults, young adults, to have 18 years, to be 18 years old or more. But these, of course, were exceptions, and of course, these were violations, okay, serious violations of the Italian legislation on this point. Third country nationals living with relatives, okay, within the second degree or with their partner, their spouse, so wife or husband, who have the Italian citizenship. Okay, so this group of people, third country nationals living in the same house, okay, with Italian relatives within the second degree, okay, cannot be removed, so they can have a residence permit for this reason. Pregnant women, or in the following 6 months after childbirth, there's a specific residence permit for this category of people, which only last, this kind of permit will only last up to the 6th month of after the childbirth, but can be converted into a different kind of into a different typology of residence permit, for example, a residence permit for working reason. Also, third country nationals in a serious psychophysical condition, for example, people who are who have a serious condition, who are seriously sick, okay, cannot be deported. And also in this case, there's a specific kind of residence permit for them to be treated by the national healthcare system. There's a specific kind of exceptional residence permit for people fleeing, third country nationals, of course, fleeing from natural disasters, okay? This is quite new. This legal provision was introduced in 2018, October 2018. this residence permit is quite rare so far. I haven't seen one in these 4 years of existence of this provision, but still it exists, and it's good to know that there is also this option. This residence permit, if I'm not wrong, lasts for 6 months, but can be at the end renewed if the situation in the country of origin is still dangerous due to the natural disaster, earthquake, just to make an example, can be renewed, and it can also be converted into for example, a residence permit for working reason. There are, of course, specific provisions to protect victims of human trafficking, domestic violence, and serious labor exploitation. These are provisions that implement in the Italian, at the national level, norms and provisions from the European legislation, or from international law, from international convention. There is also the possibility to get a residence permit for the parents of a minor. So this is a special provision which has the purpose of protecting the best interest of the minor. So basically to grow with his or her parent, for example, I don't know, his or her father, okay, to so to grow with being living with her or his father or mother, whatever. This is a very specific legal provision that could be, and this kind of permit must be cannot be asked to the police authority, but must be asked through a judicial appeal to the court, which is competent for minors. So it's a very specific and yeah, a very specific provision. There are also possibilities to regularize the position on the territory through the channel of the family cohesion, which is basically family reunification, but with the person already present on the territory. This would be a very long story, so we cannot say more about this now. And then there's this also very specific kind of residence permit that is released, that is issued in favor of persons, of third country nationals, who did something special, who carried out acts of particular civic value. But this is also something very rare and not relevant. You already know what the non-refoulement principle is. Just to refresh, let's say, your memory, this is the non-refoulement principle is part of the customary international law. So it's binding for the whole international community, for all states, no matter if they are part or not of the Geneva Convention of 1951. But the non-refoulement principle is, of course, stated in the Refugee Convention at the Article 33, as you can read, prohibition of expulsion or return, refoulement. Paragraph 1, no contracted state shall expel or return a refugee in any manner whatsoever to the frontiers of the territories where his life or freedom would be threatened on account of his race, religion, nationality, membership of a particular social group or political opinion. So basically, you cannot push back, you cannot remove an asylum seeker who's still, whose application is still pending. You cannot remove a refugee or a person who's old, who holds a subsidiary protection. There are, of course, some exceptions in case of in case of national security or public order, in case of threats to the national security or the public order of the state. But let's say that in general, this prohibition is binding and cannot be derogated. Of course, this is in practice. This happens every day, also in Italy. Okay, you see here, you have a list here of the other international convention or regional convention that provides the non-refoulement principle explicitly or implicitly, as in the case of the European Chart of Human Rights. This is not important to go through all these conventions. This was just to give you these, let's say, just to refresh a bit the memory about this principle, because this is, of course, why we, I mean, it's not why, this is the, this principle is the reason, yeah, it's the reason why we have these specific provisions for non-returnable migrants, at least some of that categories that we just saw. This is the way in which Italy implemented the non-refoulement principle in the national legislation at the Article 19 of the Italian Consolidated Act or Law on Immigration. But this is not important because basically this replicates the non-refoulement principle as stated by the international conventions, the Geneva Convention and the other conventions. Maybe it could be, yeah, useful to highlight that the prohibition of expulsion and refoulement also apply to cases in which there are reasonable grounds to believe that he or she, so that the third country national, is in danger of being subjected to torture or inhuman or degraded treatment in his or her country of origin or residence. So this is important because basically this is the way in which the Italian legislation integrated the Geneva definition of the non-refoulement principle with other prohibition stated by, for example, the European Convention of Human Rights. So, for example, the prohibition of torture or the, inhuman or degrading treatment. So the non-refoulement principle also applies to these cases. To these cases. So next, okay, yeah, I think we can. No, okay, let's do also these, the next two slides. This slide and the next one, and then we can have a break. This is just to give you a bit of context for those who are not familiar with the Italian context and with the evolution of the Italian legislation on immigration and asylum. Before 2018, the Italian legislation provided these specific kind of residence permit, which was the residence permit for humanitarian reasons, so-called humanitarian protection. And this was, and the provision was set at the Article 5, paragraph 6 of the Consolidated Law on Immigration. And as you can see, these, according to the Article 5, paragraph 6, this residence permit was issued in case of serious reasons of humanitarian nature or resulting from constitutional or international obligation of the Italian state. So basically, the Italian law provided a very broad, open, and atypical definition, which left room for the application of these provisions, so for the application of these humanitarian protection to a multiplicity of different situations, okay? Also to different situations over time, because of this open, very open definition, and general somehow definition. So the content and the requirements of the humanitarian protection was developed by the judges over time. So Italian judges started deciding on cases, on appeals of people who wanted, who asked for a humanitarian protection or for international protection, and they were denied. So deciding on these appeals, judges started defining the contents and the requirements for these kind of protection, arriving at a definitive formulation in 2018 by the Court of Cassation, which is the Supreme Court in Italy, which is the Supreme Court of Italy, which gave this formulation, this definition, let's say, developed by the Italian case law, but and then, let's say, clarified once for all by the Court of Cassation, gave relevance, okay, to the level of integration of the person in the Italian society and into the Italian labor market. So having lived in Italy for a long period, knowing the language, having social relationships, and having a job, became all criteria that could be evaluated, that could be taken into consideration in the assessment of a humanitarian protection case. Of course, along with other criteria connected to the situation in the country of origin, to the vulnerability of the person, the level of protection of human rights in the country of origin, and so on and so forth. But I mean, I want to stress these aspect of the level of integration in Italian society and in the labor market, because this will be then important in the for special protection. In 2018, the humanitarian protection was eventually abolished by the law decree number 113/2018. So in October 2018, this kind of residence permit was abolished. And this, of course, created a serious social problem at the national level, because humanitarian protection was at that time one of the most relevant residence permit. Okay, was there were 100,000 people holding these kind of residence permit, who found themselves in the situation of having a residence permit that couldn't be no more renewed because it was abolished. Okay, so they had to convert it, either to convert it into a into a residence permit for working reason, or to become undocumented, basically. This was, of course, another cause of irregularization of people. Okay, the abolishing of the humanitarian protection was, of course, a mechanism of illegalization of many people, of many migrant people in Italy. As you can see from this slide, this is how the numbers of residence permits for work reasons in orange and for humanitarian reasons, for humanitarian protection, changed over 10 years between 2007 and 2017. Okay, this is the percentage of this graph, shows the percentage of the two kinds of residence permit in a period of 10 years, how the percentages changed over 10 years. So I think we can have a break. I will have a look to the questions. Wow. Okay, now this is a comment. If I am Italian and my husband is a third country national, could his brother get a regularization? I mean, this question from Marta Piras. I mean, these let's say these specific questions on individual cases should be always, like, I don't know, analyzed in depth. Okay, I think, I don't know if this is something that involves you or some people you know. So I don't want to give an answer that could be taken as definitive, but said, put in this way, I would say no. But of course, this should be, I mean, this a closer evaluation would be needed. I see the reception center in Lampedusa as a detention center because refugees are not allowed to go out of the center, which consists adults and minors. I completely agree with Abubakar Naziru Usman, who made this comment. I completely agree with him. The Lampedusa center is actually is not labeled as a detention center according to the Italian legislation. So formally, it is not a detention center. Okay, it is not a pre-removal detention center. It is an hotspot center, but people shouldn't be kept in a condition of detention in that facility. But I know that there are people kept there for weeks, of course, against their will, to be because of the of all the procedures of identification that take place inside of the facility, which is also overcrowded, and there are also minors inside the Lampedusa the center, the Lampedusa facility, which is of course a violation of their rights. I completely agree with you. Just a comment, 100,000 of irregular migrants, there are also plenty of people in the gray area, for example, waiting. Yeah, they are not irregular, but have poor access of welfare system. They are denied to have documentation because some institutions not considered. Yeah, I mean, this comment by Natalia Moreira is Barbosa Campos is absolutely true. So I have nothing to add. I had a question, Christina Lasri, about the residence permit granted to third country nationals in critical physical condition. If they are totally recovered, does their residence permit expire with the healing condition? Do they have the option of renewing their okay, yes, basically the this specific exceptional residence permit for people who are, as you said, in critical physical conditions actually can be renewed until the condition exists. So once they recover, the residence permit cannot be renewed. So it lasts until the expiration date, which is written on the residence permit. So if they recover, for example, in May, but the residence permit expires in August, of course they are. I mean, the residence permit is valid until August, but they can no more renew it, but they can convert it. So, for example, they can find a job, as you said, and convert it into a residence permit for working reasons. And of course, they could also renew it, convert it, so switch to special protection that we will see in 10 minutes.
Sorry, Carlo, we have another question that I skipped by mistake from Lauren Cohn. And she asked, what is considered as victim of serious labor exploitation in Article 8022?
What is considered as victim of? Okay. I mean, these would be, I mean, these would worth a class on this topic, because of course it's a major, I mean, it's a very important issue. But let's say that there are standards, okay? There are criteria, not standards, sorry. There are criteria set by the law to identify cases of serious labor exploitation. These criteria are basically the same that which are, let's say, criteria or parameters, okay, that could be used to evaluate the situation and to assess the condition of serious labor exploitation. But these criteria, you can find them in the so-called Employers Sanctions Directive, which is a directive from 2009. The number should be 52, if I remember well, 52, 2009 of the European Union, which is a directive on the sanctions to, against employers who hire undocumented migrants, undocumented workers, okay? In this directive, you can find the definition of serious or particular labor exploitation. I think the directive used this term, particular labor exploitation. And these are the this is the definition that also the Italian legislation adopted for at the internal level.
Okay, thank you. Thank you all for the questions. So we
9 minutes break. A 9 minutes break. We
19:20.
Yeah.
Okay, thank you. See you.
Okay, see you in a while.
Thank you.
Okay. So we saw that before the break, we saw that the abolition of the humanitarian protection was created a serious social problem, a serious social issue, because of the number of people who were holding that kind of residence permit at that time. In 2020, October 2020, the latest reform of Italian immigration and asylum law made some changes, introduced some changes in the legislation. It touched changes that involved the administrative detention, the reception system for asylum seekers and refugees, the provisions on several types of residence permits, but most of all, the law decree number 130 introduced the so-called special protection at the Article 19 of the Italian Consolidated Act on Immigration, providing a more clear and detailed definition of the requirements, of the contents of these new residence permit, of this new protection, which the definition which was inspired by the definition of the protection for humanitarian reasons developed by the judges, okay, in particular by the Supreme Court of Cassation in 2018, okay. So let's see the definition of the special protection. As you can see, the special protection the definition of the special protection is placed, okay, straight after the non-refoulement principle, okay, the provision about the non-refoulement principle. Let's go back to that. As you can see, paragraph 1, the refoulement principle as basically taken by the Geneva Convention. The paragraph 1.1, which takes into consideration also the risk of torture, inhuman and degrading treatment, the existence of systematic and serious violations of human rights in the country of origin as a criteria to be to evaluate, to assess the risk of torture, inhuman or degrading treatments. And then in the same paragraph 1.1, the article lays down the definition of the special protection. So let's read it together. The reform, of course, this is a translation from Italian. So this is, I mean, it's always difficult to translate from, I mean, legal concepts and definitions and provisions into a different language. So for the Italians, or for those who speak or can read Italian, I suggest to after the lesson to read it, to read the definition in Italian, to read the original definition. But yet the refoulement or expulsion of a person is also not admitted when there are good reasons to believe that the removal from the national territory, so from the Italian national territory, involves a violation of the right to respect for his or her private and family life, unless it is necessary for national security reasons, public order and safety, as well as health protection. This is always the exception. To assess the risk of violation of the aforementioned rights, so private and family life, the nature and effectiveness of the family ties of the person concerned, his her effective social integration in Italy, the duration of the stay on the national territory, as well as the existence of family, cultural, or social ties with his her country of origin have to be taken into account. Okay, so basically this new protection, this new provision introduced at the end of 2020 is meant to protect the right to respect for private and family life as provided by Article 8 of the European Convention of Human Rights. This is explicitly mentioned in the report that, let's say, that was drafted by the government at the time, by Italian government at the time of the reform. So the right, okay, which is protected by these new legal provision is the respect for private and family life, as provided by the European Convention of Human Rights, and as let's say defined, developed by the European Court of Human Rights in a series of judgments, okay, concerning private and family life. You already had a class on these, so I won't say much on the content and on the definition of this right. What is important for us today, for today's class, is the criteria mentioned, provided by the law to assess the risk of violation of these rights private and family life are not the same, in case of return, okay, to the country of origin or residence. These criteria are the ones in highlighted, as you can see: the nature and effectiveness of the family ties in Italy, the effective social integration in Italian society, the duration of the stay, so the length of the stay, how long this person has been living in Italy, and also the existence of family, cultural, and social ties with the country of origin. This means that let's say, the weaker these ties with the country of origin are, the stronger is the risk of a violation in case of return, a violation of private and family life, the right to respect for private and family life in case of return. On the opposite, the stronger these ties with the country of origin are, let's say, the lower is the risk of violation of these rights in case of return. But of course, so this means, of course, that there must be a let's say, an evaluation and the balancement between these different criteria. Okay, so the first criteria with regard to the life the person built in Italy, and the links, the ties with the country of origin, with the family who still lives there, if there's any, with I don't know, organizations, groups, whatever, from the country of origin. Okay, this was let's say, an overview of the contents of these rights as defined by the European Court of Human Rights on the basis of the Article 8 of the European Convention of Human Rights. But you already had a lesson on this with Diego, so I don't. You can also, of course, let's say, review the lesson going, I mean, on watching the registration, watching the recording, which is already uploaded. So let's skip this slide and let's go to the procedure very quickly. The procedure to apply and get, in case, the a residence permit for special protection, which is, I haven't said that yet, but I mean, this is very important in the, for example, in our daily practice at the legal clinic of Rome, because this special protection, this legal provision is very important, because this gives us the chance to support many people in getting a residence permit, in regularizing their position on the territory, people who otherwise would not have any chance of getting a residence permit. So I mean, I made among the different residence permits that I have listed at the beginning. I've decided to focus on this because this is an actual tool. I mean, this is a tool that could be actually used in many situations and in support of many people, of a quite large number of people. So it's important that everybody knows that it exists and that can be used. There's a hand raised by Adele. I don't know if I can just quickly go through this slide and then I leave you the floor. I mean, I'll make you I'll authorize you to join, to step in. So let's quickly go through this slide. It's very easy. The request must be the application for special protection must be submitted to the local police immigration office, okay, of the place where the person lives. But the recognition of the special protection, as it was for the humanitarian protection before 2018, can also result from an asylum procedure. So if a person applies for asylum and he or she doesn't meet, let's say, the requirements for the recognition of the refugee status or international, of subsidiary protection, the authority could issue a special protection permit, residence permit. So basically, there are two ways to apply for special protection. Through, let's say, the ordinary one, which is going to the local police immigration office and applying for a special protection, and going through the asylum procedure and the asylum application. And of course, the recognition of a special protection starting from as a result of an asylum request could also happen before the judge. I mean, as the result of an appeal for international protection. The competent body to assess the requirements for special protection, so to evaluate this application, is the Territorial Commission for International Protection, which is the public body competent for asylum in first instance. This is an administrative body, and this commission evaluates the request, evaluates the application, and then transmits a binding opinion about this request, so about the request for special protection, to the police authority where the application was lodged. Okay, the police authority do not have any competence in the assessment of the request. Okay, so the police is only competent for receiving the request, transmitting the file to the Territorial Commission, and then to basically notify the decision to the person concerned. Okay, this is very important because, of course, I mean, it happens that police authorities claim to have a competence on the evaluation of this kind of demand, of requests, for example. And so it's important to always remember that they are not competent, okay, for evaluating for example, the existence of the requirements or whatever. The requirements of special protection, so for example, social or labor integration, are also admitted as new elements in case of a new asylum application. What does it mean? It means that, for example, if someone made an asylum application 2 years ago that was rejected 2 years ago, and now wants to make a new asylum request, his or her social integration, for example, so the life he or she built in Italy in since the arrival must be considered as a new element in the asylum application, so that the application cannot, I mean, should not be dismissed as an identical asylum request, I mean, asylum request identical to the previous one that was already, that has been rejected, okay? Because according to the Italian legislation, if you lodge a new, I mean, an asylum request which is identical to a previous one that was rejected, the Territorial Commission will dismiss and declare it inadmissible, okay, with many consequences on the legal from a legal point of view that we don't have time to go through. So social integration, labor integration, the construction of social relationships in Italy, of a life in Italy, are all things that can be presented as new elements for a new asylum request, a second or a third asylum request. The residence permit for special protection lasts for 2 years. It is renewable. It can be converted into a work or family residence permit, but also into a permit for study, which I wouldn't suggest, or of course, after 10 years of regular stay in Italy and with all the criteria and all the requirements provided by the law, it can be also converted into a EU long-term residence permit. The status of special protection holder gives access to most of the social rights and welfare services. This is, let's say, that it's a quite strong legal status. Let me see. So I cannot see the chat. I don't know why.
We want to raise some question or?
No, Adele wrote, yeah, yes, no problem. Just wanted to add that to my knowledge, is tricky because it's renewable every 2 years, but it's not converted into for work-related reasons. No, it could be converted. Is there a backlog of applications for special protection at the Territorial Commission? If so, are there plans to further diminish its capacity by the new government? Kyle made this question. I'm not sure what he means, but if I understand well, you mean that the new Italian government is willing to reform it, to abolish it, something like that, as it happened in 2018 with the humanitarian protection? I don't know. It can happen, but I have no information. I have no clue about let's say of future of reforms in the of the immigration law in the next future that may, let's say, reform this provision. Just a question on the practical procedures. Do we disregard the kit postale for ship? Yes. You cannot apply for special protection through, I mean, using the kit postale. you cannot use the so-called kit postale, which is basically an application made by the postal system. You have to go physically there. Why do you not recommend study residence? I mean, no, it's not that I don't recommend the study residence permit. I wouldn't recommend to convert a special protection into a study residence permit. That's what I wanted to say. Because it lasts for, I mean, for a shorter period, and you can only work up to 20 hours per week. So it's it's for students, for international students. So it's I wouldn't recommend it, but the permesso di soggiorno per cure mediche under the umbrella of special protection? No, it's let's say under the umbrella of non-refoulement, okay? Because and of course we are talking about we're speaking about the exceptional residence permit for health reasons, okay? The one provided by the Article 19, okay, of the Italian Consolidated Act of Testo Unico dell'Immigrazione, not the other one, because there's also another residence permit for health reason, which is different, because you have to apply from your country for a visa for health reason to get that permit. So it's a different one. This one is for people who are already in the territory without a residence permit and have suffer from a serious condition, okay, which could also be psychological, and for this reason cannot go back to their country of residence or of origin without facing a serious harm, okay, to their fundamental rights because of this condition. Okay, so it doesn't fall under the umbrella of the special protection, but goes, let's say, more broadly under the umbrella of non-refoulement. I hope I answered. Okay.
But if someone has some question to do online, we can turn on the mic so you can speak.
Yeah,
and do
I
your
wanted
question.
to say a few things about the amnesty for undocumented migrants, but we are running out of time. I will go very quick, so you will forgive me for this, but it's 7:45, so we have to go very, very quick. So I think that the topic of the amnesty, it's interesting, especially for those who are not familiar with the Italian way of managing, let's say, migration, with Italian migration policies, but it's not that useful from a practical point of view. And I wanted to give some hands-on legal knowledge and not and so I will be very quick, and I won't go, let's say, in depth in the in this topic. So basically, the amnesty is an exceptional measure adopted by the government, which, under certain conditions, allows undocumented migrants to regularize their position on the territory. So it's an exceptional measure. The European Union doesn't like it. So European Union doesn't appreciate when governments, especially when the Italian government adopts this kind of measures, because according to the European Commission, these measures are pull factors for irregular immigration. Of course, I completely disagree, but this is how the European Commission understands, and yeah, these kind of measures. Of course, in 2020 there was the COVID emergency, the pandemics, the pandemic. Italy faced a very serious situation, went through a very severe crisis. So it was much easier to adopt a measure of amnesty for undocumented migrants. It was, in fact, justified by the government on the health crisis. So one of the reasons, official reasons behind this measure was to make sure that undocumented migrants had full access to the healthcare system and avoiding the spread of the virus in marginalized communities. So the protection of the public health, basically. But that's not important. That's just a bit of context of this measure. Traditionally, Italy has a long history of amnesties for undocumented migrants. Traditionally, the features of these kind of measures are that they are adopted through exceptional means, legal tools like emergency decrees and stuff like that. So they are exceptional measures. One of the requirements is having a job or a job offer. Okay. There are always, or most of the time, limitations to specific sectors of the labor market. So you cannot apply for the amnesty if you don't have a job or a job offer in that specific sectors that are provided by the amnesty. Most of the time, people have to prove, to demonstrate that they were in Italy before a certain date. Okay, so that they did, basically the point is they have to show that they didn't enter after the approval of the amnesty. Okay, no, the idea of the pull factor. There's always something to pay to have access to the amnesty, so a fee, a tax, something. And there are obstructive causes, but these basically you cannot apply if you have been convicted for specific crimes, for serious crimes, violations of the criminal law, stuff like that, for example. These a chronicle of the amnesties for undocumented migrants that Italy adopted in the last 34 years, let's say, before the last one in 2020. As you can see, these amnesties are basically ordinary measures to deal with the issue of migration, to manage migration in Italy. As you can see, these amnesties have all been approved along with the reform of the immigration and asylum law legislation in Italy. So basically, almost every time that the Italian government decides to reform the immigration and asylum law, it also approves an amnesties for undocumented migrants. It's not always like that, but most of the time it happened. this was okay. There's a line. There's a few words in Italian because this slide was in Italian at the origin. So the 2020 amnesty provided 3 options for regularization. The first one was actually the regularization for undocumented migrants. So was the possibility to get a residence permit for undocumented migrants. The second one was to regularize labor relationships. So labor relationships that were illegal, that were irregular, okay? And the third one was both the hypotheses, both the options. So basically regularizing a labor relationship, a labor relationship, and the position of the worker. Okay. The only one that is of interest for us today is the first one. So the possibility to regularize the position on the territory for undocumented migrants. With regard to this option, to these hypotheses, there were 2 different channels, okay, for the regularization of undocumented migrants, as said. The first one basically absorbed more than 90% of the applications. So almost all the application went through this channel. So we will say a few things about this one. We will leave the other one because was as said, a few people, and the application made through the second channel have all been decided. So the procedure is closed. While instead the procedure of the first channel is still ongoing. The requirements to apply for regularization for the amnesty through the first channel, the most important requirements were having a work contract or a job offer. Of course, an irregular work contract because, as said at the beginning, it is impossible for an undocumented migrant to have a regular job contract. To have this work contract or a job offer in one of the 3 sectors defined by the measure, so agriculture, domestic work, and care labor. Being in Italy before the 8th of March 2020, and to be able to show it, okay, with a quite wide array of documents that the person could attach basically to the application to show that he or she was living in Italy before the 8th of March. There was a fee. There were income requirements for the employer, of course. And there was a time window for the application. So from the 1st of July to the 15th of August 2020. The results of these amnesty, it was a bit of a failure, to be honest. There were 207,000 applications for the first channel and 13,000 applications for the second channel. You can also see the distribution of the applications. So 85% for domestic and care work, only 15%, sorry, for agriculture and connected activities. at the beginning of October 2022, so more or less 1 month ago, there 32% of the total number of applications were still pending. So 1/3 of the application made through the first channel were still pending. Almost 13% were rejected of the applications already decided, already processed by the Italian authorities. Of course, many people, many undocumented migrants have been victims of fraud and illegal practices, and their applications were, of course, rejected for these reasons. And of course, there are remedies in case of rejection. There's the possibility to appeal the rejection before the administrative court, which of course it means that you have to be quick to meet the deadline for the appeal, and you have to find a lawyer who's willing to support you. Appeals before the administrative courts in Italy are quite expensive and can take quite a bit of time. So it's not easy, basically, to appeal a decision that rejects the application for the amnesty. But of course, people who applied for amnesties could have the requirements, could meet the requirements for the special protection, because they have been living in Italy for many years. They have many social relationships in Italy. They have maybe relatives, family members living in Italy, and of course they have been working for at least for a bit of time at the time of the amnesty, but maybe also in the past. So most of the time, people who applied for the amnesty also meet the requirements for the special protection. So there's also an option, I mean, that could be taken into consideration in the case of rejection of the application for the amnesty. I think I'm done. I will take the questions if there are any. I see one question here in the Q&A chat. I have to go in 5 minutes, so if you have questions, please do them now, because otherwise I will go. But let's answer to Abubakar. At the moment, there is a delay in releasing of renewed documents in Italy, about 6 and 12 months. Could there be a reason for that? Actually, Abubakar, I cannot answer. I mean, I cannot answer because I don't know why. I think in Italy, I mean, as far as I know, I mean, in my experience, the procedures for the release or for the renewal or the conversion or whatever of residence permits in Italy are always very long, take always a lot of time. So I think that probably the COVID situation somehow made the situation worse in the police offices, but I don't know if there are, let's say, specific reasons for this delay that you mentioned. Let's say my girlfriend is an Italian citizen and I applied for a refugee in Italy. Let's say my girlfriend is Italian, and okay. But let's say we got married shortly after the application. Will my refugee application still continue, so I will be considered as a refugee, or am I not a direct refugee because I got married? No, actually you can decide. I mean, if you get married with an Italian citizen, of course you have a right to get a residence permit as in your case as the husband of an Italian citizen. And then after some time, it depends on the specific situation, you could also apply for citizenship. But if you want that your refugee application is evaluated, is assessed, and you, I mean, and you want a decision about your refugee request, I mean, asylum request, sorry, of course you can have it. You are not obliged to withdraw your asylum request, or neither the authorities are allowed to dismiss it because you got married with an Italian citizen. And last but not least, comment. Natalia Moreira, 85% of domestic and care work. That's interesting because of the gender component of those activities. Yes, of course, I totally agree with you. It's an interesting number because also because along with the protection of the public health, let's say, the amnesty was justified because of the need of workers in agriculture. There was the fear at the time, I mean, because of COVID, there was the fear of labor shortages in agriculture. And so the government said, let's do these amnesties so that migrant workers can go working in the fields and meet the demand of that sector, and that's also why the measure was presented by the Ministry of Agriculture, the Italian Ministry of Agriculture was the sponsor of this of the amnesty, but then finally that was the result, let's say, that was the percentage of requests from the agricultural workers, from farm workers. And of course we could have a long discussion on why this is the situation, why this is the outcome of the measure. I have an opinion, and maybe you have other opinions. It would be nice to have a chat on this, but it's getting late. And of course, as you said, it's interesting for the gender component, for the gender composition, I mean, of workers in the field of domestic and care labor. Thank you, Lauren, for your appreciation. You are great too. You all are great too. We are very happy of having this training program. So I wrap up, and I think we can close the lesson. We can finish here.
Yes.
And
thank you to everyone. As I say at the start of the lesson, because now we have a lot of people here, the lesson that we speak the last week, we skipped the last week. We are still trying to organize that, so we'll send to everybody the email when it will be attended. So thank you so much for being here tonight. Thank you. Yeah. See you Thursday.
See you, yeah, on Thursday with the lesson on basically the same topics of today's class, but with the focus on the Spanish legislation. So